All right, when I call your name, please say present or here, raise your hand so I can acknowledge you for the docket. And after that, council, if you want to line up over here to my left, your right, on those that are agreed, I'll start calling you. Get you in and out. Devontae Bird. Devontae Jamal Bird. Michelle Cook. Yes.
The motion is Ms. She's incarcerated in Texas.
Okay. State has tendered a motion to dismiss and cause number CR 2115. Court is granting that motion and signing the order of dismissal. Jason Farney. Elaine Jeffrey. Make sure you say something in case I don't look up. William Petty. William Lynn Petty, probation extension. Cindy Smith. Cindy Marie Smith. Shannon Wingo. Probation extension, but William Petty also. Yeah, I don't have work for Wingo. Matthew Hogg. Robert Sandberg. Mr. Petty. That was Mr. Petty. Thank you, Joe. Zachary Duncan. Jamie Gant. She's outside. Thank you, sir. Matthew Kearns. Tyler McInnes. Tyler Elizabeth McInnes. Logan Bundrick. Grace Fowler.
Your Honor, I'm here. She's having difficulty getting up here because of the short recess.
Jason Nichols. Danny Dittman. For the record, CR 21-167. Myra Garcia Escobedo, waiver of arraignment filed, approved, pretrial set August 10th. Is Michael Green here? All right, Mr. Green, your case will be at 10 a.m. and there's another judge presiding over your case, Judge Banner. So when he gets here at 10 o'clock, I will step down and he'll step up and he'll hear your case, okay? Is there anyone who's in the courtroom whose name I have not called? Yes, ma'am. Stacy Baxter. Do you have an attorney, Miss Baxter? No. Are you here for criminal court? What are you in court for? Divorce. You're probably downstairs. Most likely in the county court at law, Judge Winters. So if you'll just go down to the second floor and the courtroom is on that side. So just go down the steps, and when you come off the steps, if you go down these steps, it's on your left. If you go down those steps, it'll be on your right. You're welcome. Anyone else? Anyone else named that has not been called? Counsel, anyone ready? Mr. Schmidt, you ready? CR 2136, Robert C. Sandberg. Mr. Sandberg, if you'll come to the middle podium there, please. Show Mr. Podium's, I'm sorry, Mr. Podium. Yeah, Mr. Sandberg's at the podium, so he's set for docket call today.
Yeah, guys, Ms. Heisel laying off the last seat. Our plan is to highlight, I believe, that the nature of that last seat. I've proposed a counter to Mr. Woodback. It's not his case in town. I know the case has been reset once or twice, once because the officer didn't turn in photographs and not all once. We've asked for a little more time. If this case went to trial, it would have to be a major Chinese interpreter. So they'll also have to try to figure out, I mean, we're obviously right there, but we're not there. And so we're going to see if we can come up.
Does the state have a position?
Judge, state that you're waiting, my understanding is that that's in trouble. Would you come in and talk with us? Severe language barrier. And then we can reach a resolution.
Does that on Sunday, for the rest of the
Okay, August 10th will work. And so this is gonna, unfortunately, this will have to be the last docket call, because I show today's the third setting for docket calls, so.
I understand.
All right, Mr. Sandberg, we're gonna set you for your final docket call on August 10th at 9 AM.
And then we'll fill that out. And I'll get it signed.
All
Can you post very briefly on
Yes.
just that seat on
Mr. Schmidt. Danny Dittman, CR 18-7. Mr. Dittman set on a motion to adjudicate.
Executive states offers on the MTA.
All right, court will set Mr. Dittman for contested hearing on July 29th. And that'll be at 9 a.m. And Mr. Schmidt, can you tell me what the offer was that Mr. Dittman rejected? Yes, Mr. Dittman, you're free to go. Mr. White, are you ready? Logan Bundrick.
Your Honor, this is the first segment on MTA and also the right next on the case that we both CRA tickets. Like we don't have discovery on that I did what I did run off. And this bucket's name is spelled correctly. We understand the charges that we brought against this and we're waiting.
All right. CR 18391 is not a count alleged in CR 16630. Okay. All right, court will find that Mr. Bundrick has waived the formal requirements of arraignment in CR 18391. Court will enter his plea of not guilty into the record. We will set Mr. Bundrick for hearing on. Do you know if you're coming back at a certain date in August, Mr. White? Do you have any vacation letters or anything?
Oh, I don't have, I could try. But, August 10th, probably, that's Tuesday.
That's the Tuesday. We also have that Thursday, August 10th, August 12th.
August 10th.
Okay. All right, Mr. Bundrick, order you back on August 10th at 9 a.m. 480 State versus Shannon, Don Wingo. Ms. Wingo, you're before the court on a proposed probation extension. I see here that you're wanting to extend your community supervision for a period of 6 months, which would give you a new community supervision ending period of January 13th of 2021. What's the reason that this court should extend your probation?
I'm trying, I had a lot of stuff just come up in between. I had the cases in Hunt County also, that I just started this finally open. But I got custody of my son back finally, and I lost my funding for my school, but I had to allocate some money there that kind of took away. I had a lot of financial stuff, but I wasn't sure how to handle, but I did custody back my son. I did graduate from college. May 14th, my associate's in psychology. Now that my son is back and I'm much back news, I don't have all that money going over there. I do get my grant and my loan next month through TJC. And I'll actually be able to pay off what I owe here again. I didn't know what else to do with custody with my son and the last semester of my school. So
If this court extends your community supervision, do you believe that it will help you be successful in probation?
yes, sir. I've been successful all the way through. I just money became an issue.
All right. And has anyone threatened, forced, or pressured you to make you feel like you needed to extend your community supervision?
No, sir.
All right. Court will approve Ms. Wingo's extension of her community supervision and order it to end now on January 13th, 2021, a 6-month extension. Court will also amend the court costs, attorney fees, condition M1. All right, Ms. Wingo, if you'll come over here and meet with Ms. Burns, then she'll give you paperwork and you'll be free to go. Mr. Petty? This is CR 16-325 State versus William Petty II. Mr. Petty, you're asking the court to allow you to extend your community supervision period for a year. What's the reason for that?
I've been fighting that kind of business
Do you believe if I extend this for a year that you'll be able to pay off everything you owe and successfully complete your probation? All right, Mr. Petty, court's going to approve the extension for 1 year. Court's also going to waive your UA and probation fees during that time. All right, come over here and you meet with probation. They'll get your paperwork and you'll be free to go. She'll be with you in just a minute. Is Cindy Marie Smith here? Is Tyler Elizabeth McInnes here? This is CR 16416. The state has filed a motion to adjudicate your guilt and revoke your community supervision. Are you going to hire an attorney to represent you? I see that you've applied for court-appointed attorneys, but based on your income and your assets, you do not qualify under the law for court-appointed attorney. So what I propose we do is I'll reset this case for 30 days, give you an opportunity to go out and speak with some attorneys and try to have one hired to represent you on this felony matter. Okay? So what I'm going to do is I'm going to reset you until August. It's a little bit more than a month, actually. So I'm going to reset you to August 12th. Okay.
Don't worry.
All right, Ms. Jeffrey, the deputy here is going to bring you this form. There's an X here for you to sign. We're going to give you a yellow copy. We're going to have your reset date on it, okay? Thank you, sir. Did Ms. Escobedo come see y'all this morning about her pretrial release papers with Mr. McCaslett? Filed a waiver of arraignment, and I told, Patty told him to come. I just want to make sure she did that. Did she punch it in this one?
Yes.
She did. Okay, good. Yeah, thanks. Matthew Hogg. CR 20125. All right, Mr. Hogg, if you'll raise your right hand, I'm going to place you on your oath. Mr. Hogg, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Are you having difficulty seeing?
Yes.
Do you wear glasses or contacts?
I wear glasses, but I lost them.
Okay, can you not see me very well?
No.
All right, I'll tell you what, come on up. We're gonna have you come right up here to this square right here. You see it? Does that help? Is that better?
We're still blurry, but. I
Oh,
see.
but it's better than being back there, right? Okay. All right, Mr. Hogg. Are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to discuss your case with him, have all your legal questions answered? Kind of hesitated on that. You don't feel like you've had enough time to talk about your case with him? And are you satisfied that you understand everything about your case and what you're doing here today?
Well, I don't like the.
Well, I don't, it's not,
Probation, like having to report more than once a month.
well,
I
I'm
don't
not,
even have a vehicle.
well, I'm not asking you what you like and what you don't like. Most people in your shoes don't like being in court. They don't like a judge telling them what they're going to do, and they don't like peeing in a cup. And they don't like paying their probation fees, right? So it's not about what you like and what you don't like. It's about what do you understand? So have you had enough time to discuss the case with your attorney and have all of your questions answered from him?
Yes.
Okay, you see the distinction between what you like and what you understand? Is there anything about the plea papers that you've read and signed today that you don't understand?
No, I understand.
And I understand that there may be some conditions of probation that are difficult to comply with if you don't have transportation. Have you discussed that with your attorney?
Yes. So if you discuss.
If I may just. add
Please.
Something that might trouble you. And so what may happen. Originally, this case was going to be set up and he was going to go to Senate for the 2-year program. However, Senate is not taking any patients at this time. So therefore, he's been put on intensive supervision instead of Senate. That was a conversation he and I had a couple of times, and he kind of wanted the Senate court because he'd had 2 years of a place to live and food and a job. That was some of his concerns. I think that's what his concern was, Judge. I just wanted to point that out to the board that the intensive supervision came as a result of not being able to.
And this charge is what, evading arrest or detention with a vehicle?
Yes.
I'm assuming that safety was not on the,
No,
not an option.
No, sir. And cynical is something like that action asked for. It's not something that the state necessarily can.
So he's mentioned to me that he has a concern about his ability to comply with probation without having a vehicle. Have you discussed that specifically with him?
Not specifically. I didn't know that was an issue until just before we signed the plea papers. He is gainfully employed. And I believe, if I'm not mistaken, you had at one time along the way found your employer to help you, or a friend or somebody was going to help you get to and from probation. Is that correct?
Yes.
Okay. We had this conversation, Judge.
Mr. Hogg, do you believe if I put you on probation today that you can meet all of the requirements?
Oh, without doubt.
You believe so?
Yes, sir.
So tell me again what your concern was about, or when we had that discussion about what you didn't like. Tell me about that. You said something.
Just like making it to probation, like, once, twice a month. Because like I did have a car, but then since I don't have a valid driver's license, every time I save up and buy a car to get myself back and forth to work or to like the grocery store, or like McDonald's or whatever, as soon as the police pull me over, they take it. And then I'm back on foot
Yeah, and you understand why they take it, right?
because I don't have a valid driver's license.
Yeah, I don't want you on the road without a valid driver's license. Probably don't have insurance either, do you?
No, I have insurance. And like the registration office was closed here in Canton and in Willis Point. And so I couldn't get it transferred to my name. But Yeah, yeah, that's pretty much the only concern is I don't have transportation.
Well, you know,
Every time I get transportation to like handle everything, like as soon as law enforcement pulls me over, they take it away. And then I'm asking for rides again.
well, Mr. Hogg, do you have a family support system that will take you back and forth to probation?
Negative.
All right, then I'm gonna tell you right now, I don't think you'd be a successful candidate on probation because you have
I mean,
to.
I have neighbors and my boss that will like take me.
Do you think you have sufficient transportation with the probation department? With the help of friends or family?
Yeah.
employees? So the judge is concerned about putting you on probation. If you're telling them that you can't make it to the probation department to begin with.
No, I can make it. It's just like, like,
Just
what
more
if
of
I
a burden.
can't?
Which is just more of a burden on you because you don't have transportation for it.
Yeah.
But you understand-
I'll figure it out,
But you understand you got to report, right?
Yeah, I know.
And you and I have talked about this before. You tell me you can do all the conditions, right?
Yeah.
And if you're being placed on intensive, you're gonna have to report weekly. You understand that?
Yeah, that's what I was asking about too. I don't understand why I'm being placed on intensive probation.
I'm spitballing here, probably because you got a severe drug problem and you couldn't get into drug rehab, and this is the
No,
next best
I only
alternative.
signed up for Cinecore, so I have a free place to stay and a job to save money for 2 years straight. But then I found out my boss was gonna still let me work at Crown Mobile Homes, and I got my house back by the lake, so that's why I didn't need to go to Cinecore anymore.
Things are moving in the right direction.
Yeah, for sure.
And he can come to your boss, just lives down the street from you. One of your supervisors that was right.
Yeah,
down the
my
street.
coworker. Yeah, I have to ride to work. I got my house back, I got my job back. So now I'm making it to probation once a week. I don't know about that.
Well, then I tell you what, I don't know about this. I don't know about this plea agreement then, because Mr. Hogg, if you don't show up as ordered once a week, then they're gonna file a motion to revoke your community supervision. We're just delaying the inevitable that you're gonna come back and end up back in jail, and you're gonna say, well, I couldn't report because I didn't have a car and I couldn't find nobody to take me, or every time I get a car, the police take it back.
Yeah.
So let's do this, Mr. Stevens. I'll recall the case, give you some more time to speak with Mr. Hogg, but those are some obvious concerns that I do have that you've already pointed out. Is I don't want to set Mr. Hogg up for failure. And I'm glad he's moving in the right direction. I'm glad he's got a job. I'm glad he's got a place to stay. I'm concerned that if we put him on community supervision and he doesn't have the means to make it happen, then we're just setting him up for failure.
That is-
I'm gonna hold on to this paperwork. Ma'am, what's your name? Oh, for Mr. Green? Okay, yes. And here's Mr. Green behind you here. And I told him that as soon as Judge Banner gets here, then I'll step out of the way and let y'all proceed. Thank you. All right, Mr. Woodwhite, do you know if we have anything else ready at this time? Okay. Say that again. Mr. Kearns, I would just recommend and encourage you to step outside and call Mr. Hyde's office and inquire about Ms. Bush. Otherwise, I'm gonna leave you sitting here all day waiting on her. So might have to help yourself out by making a call to your attorney, okay? Yeah, I just asked her. So we haven't called any of Mr. Ashmore's clients, correct? So Miss Fowler and then it's Mr. Nichols. Is he outside with Mr. Ashmore? All right, court's going to stand in recess and await Judge Banner. And then whenever Judge Banner arrives, I'm gonna let Judge Banner call his case and then we'll resume Mr. Staub and anyone else who's available. All right, so we'll stand in recess until that time.
Good morning, Sharav. How are you?
Hey, good morning, Patty. I'm doing well. How are you?
Oh, I'm doing good. We are trying to. I've called Judge Banner, but he doesn't answer, so I don't know if he's on his way. Um, so that's what we're waiting on is for Judge Banner.
Okay. Is
Have
the
you-
prosecutor going to be there in person or?
They're both here,
Okay.
but we haven't seen Judge Banner yet, so that's what we're waiting on.
Okay. I have to be back in the Cherokee County courtroom for pretrial at 10:30.
Okay.
If anything happens, do you think that if the judge doesn't show up, or something happens, do we think we can do it right after that?
He has a 10:30. He needs to be back in Cherokee County courtroom, and then okay. So go ahead and do that, and then if you don't mind hopping back on, and then surely we'll have heard back from Judge Banner by then.
Okay. All right.
All right. Thank you.
I'll be back. Patty, you have my cell phone, right?
Yes, sir.
Okay.
So if anything changes, I'll let you know.
Okay. Thank you.
Thank you.
Mr. Murray.
Good morning, Judge.
Good morning, sir. Okay, you have a 10:30 hearing, correct?
Judge, I told them that as soon as I'm done with this hearing for Mr. Green, I'll be into the courtroom, so it's kind of loose about 10:30.
This is what I surmised. I believe that Judge Banner's probably had a scheduling issue or forgotten about us. So he was trying to log in via Zoom. I don't know that he's going to be successful at doing that. So what I would like to propose is just to reset the case until Thursday. We can set it up as Zoom, maybe Thursday at 11. What does your schedule look like for that?
I'll be in Van Zandt County on Thursday morning, Your Honor.
You'll be in court on Thursday morning?
That's right, Your Honor. I have a few cases set for pretrial and docket call that day and one case set for a plea. So I'll just be able to do that right after those cases.
Okay, and stepping in is Miss Husky and Miss Shepherd. They're going to be the assistant DAs handling this from Kaufman County. They've not been sworn in yet, and so that needs to be undertaken by Judge Banner, because I don't believe that I can even swear them in since I'm recused in the case. So that's something that was going to have to occur here today prior to the hearing. With Judge Banner not being here, that makes it a little more difficult. Hang on just a moment. Ms. Tabraham has some information for me. Tell him that we're going to need to swear in the assistant DAs and that Mr. Murlater is available. He'll be here at Thursday 11. And if he wants to appear Thursday at 11 by telephone, I'm sure we could probably do that. And Ms. Husky and Ms. Shepherd want to appear via Zoom, and Mr. Murlater will be here. We could make that work. But all right, so Judge Banner's asking to appear via telephone today, but I think that's going to be difficult considering we need to swear in the assistant DA. So I think out of caution, we should just wait for a moment. Let's ask Judge Banner if he can either appear on Thursday when you're here, and then if not, then maybe he can appear via telephone on that day, and we can figure out the swearing in before that time.
Yes, Judge. And Mr. Green is present there. Is that right?
Mr. Green is present. Yes, he's sitting here in the courtroom, and he's been here since 9 a.m.
Okay.
Go ahead.
I was just going to ask the court or ask Ms. Tabraham to just fill him in and ask him to do a reset if Judge Banner wants to reset this to Thursday.
Okay, and I'll make sure we handle that for Mr. Green. Mr. Green, are you hearing all of this? Okay, I'll go over it with you in just a moment. Okay, we've got some scheduling issues that we're trying to work out, so I'll be with you in just a moment. Okay. All right. So, Ms. Husky, I didn't ask you. Would you be available Thursday morning, and we could set it? You're going to be here at 9 a.m.
That's correct, Judge.
Okay, and if you want, like I said, I've already extended to Ms. Husky that if she needs to Zoom, that we can set that up for her, as we do you. So, all right, so we'll just wait and see what Judge Banner says.
And Judge, I don't have any objection to both Ms. Husky and the district attorney who's present. I don't think I've met her being sworn in ex parte with Judge Banner. I don't believe I need to be on the record for that, so I don't have any objection to that.
Okay, all right, and so we may have them do that over the phone today. Okay. All right, so I'm gonna step off the bench for a moment. If you'll just hold what you got, I'm gonna run, check on Patty and Judge Banner, and be right back.
Yes, Judge.
Mr. Green, if you'll come up, Mr. Green, I'm gonna bring Mr. Green right up here. Mr. Green, if you come all the way up here to this little square area you see on the floor. All right. All right, so Mr. Green, my name is Judge Chris Martin. I am the judge of this court. However, because I believe that the case that you're involved in also involves another judge in this courthouse that I work with, I will not be hearing this case. So I've recused myself because I have a working relationship with Judge Winters, who I believe is the named complainant or victim in the case. And so you're going to have another judge that's going to preside over your case. And he was unable to be here this morning. I believe that maybe some wires got crossed or he wasn't able to connect online. So what we're going to do is we're going to reset the case until until Thursday, all right? Day after tomorrow, this coming Thursday. Yes, sir. At 9 a.m. Okay. And these ladies here to your right are the prosecutors, and they're going to be sworn in by this presiding judge, Judge Banner. And then on Thursday, then Mr. Murleader and the prosecutors are going to make announcements in your case. And so I'm just going to ask that you be back here Thursday at 9 a.m. Okay? Yes, and I'll tell you what, I'll write it down for you. I'll write it down for you, and I'm going to give you a copy. Okay?
Okay.
And Mr. Green, I'm going to give you a call later today as well.
Okay.
Expected around 4:30, okay?
Okay. Appreciate it.
Yes, sir.
I don't suppose any of you have the case number handy, do you?
Yes. It's
She has it, Mr. Murleader. Thank you. All right, Mr. Green, I'm just gonna have you sign right here on the X, and then we're gonna tear it apart. We're gonna give you a copy, and then you'll be good to go, and we'll see you on Thursday.
7, 8, 9 a.m. back in this room Sunday. Okay, that. Sir. Or, so, okay.
All right, thank you, Mr. Green. You're free to go home.
Okay, thank you.
Thank you, sir. All right, and Ms. Heskey, if you can just slide over to this way, that way Mr. Murleader can see. There you go. Okay, so in speaking with Judge Banner, I think what we're gonna try to do is we're gonna ask that you go meet with my coordinator before you leave. And let's get a copy of the statement of officer and the oath. We're gonna send that to Judge Banner. And then we're gonna ask Judge Banner to contact you between now and Thursday. Go ahead and do that oath and statement of officer over the phone. And then that way he can sign it. And then on Thursday, we should have that back from him. And then we'll just set it at 9 a.m. Mr. Murleader's already going to be here at 9 a.m. rather than setting him at 11. And then, and I think Judge Banner's planning on appearing via Zoom. Says that he believes he can do that. And so at 9 a.m. So if Judge Banner can get zoomed in at 9 a.m., then we'll just let that be the first case. I'll call the docket, and then we'll let that be the first case. That way you're not held up waiting. Okay, and then we'll get Mr. Murleader's on his way after that. Okay, so if you'll go see Ms. Tabraham, leave her a copy of that. We'll send it to Judge Banner, and then hopefully and maybe some contact information for your office, and we'll ask Judge Banner to give you a call between now and Thursday. Swear you in over the phone. All right, thank you all, ladies. Sorry for the confusion. All right, thank you, Mr. Murleader. Appreciate you, sir. I think I gave you 1 minute to prepare for your next hearing.
Yeah, thank you, Judge. Thank you for facilitating this. I appreciate it, Judge.
Yes, sir. Yes, sir. Sorry for the confusion on that.
Yes, sir. Have a good day.
You too. All right, Mr. Staub, are you ready? All right, this is, are we proceeding on both Ms. Gant and Mr. Duncan or just Mr. Duncan? Just Mr. Duncan. Okay, this is cause number CR 2384, State versus Zachary Perry Duncan. Mr. Duncan, if you'll raise your right hand, sir. Mr. Duncan, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Your name is Zachary Perry Duncan, is that right? And Mr. Duncan, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Derek Staub. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all of your questions answered? Is there anything about the paperwork that you've reviewed and signed today that you do not understand? Mr. Staub, do you believe your client to be competent today? And you've explained to him his legal and constitutional rights? All right. Mr. Duncan, you are charged by indictment with a state jail felony offense of possession. Actually, it's a third-degree felony. Is that correct? Okay. So you're charged by indictment with a third-degree felony offense of possession of controlled substance, penalty group 2, greater than or equal to 1 gram, but less than 4 grams. But I see here that the proposed plea agreement is for you to plead guilty to a lesser offense of possession of controlled substance, penalty group 2, less than 1 gram, which is a state jail felony. And then furthermore, to be prosecuted under section 1244B of the Texas Code of Criminal Procedure, which would be that the prosecution would proceed of that of a misdemeanor, which means that the range of punishment, the maximum would be 365 days in jail, and the maximum fine that could be imposed would be a $4,000 fine. I see here that the plea agreement is that you plead guilty to that offense in exchange for the state's recommendation that your punishment be assessed at 5 days confinement in the county jail with credit for 2 days, with you receiving a fine of $4,000, a $180 restitution, and also court costs of $290 and reimbursement fees of $35, with you serving the remainder of your jail time on Friday, July 16th, submitting yourself to the Van Zandt County Jail by 6 p.m., with you being released 2 days later on July 18th by 6 a.m. Mr. Duncan, is that your understanding of the plea agreement? And Mr. Staub, you've already indicated this, but it would also be including the consideration of 2 cases, DA 2020-522 and DA 2020-521. Is that your understanding of the plea agreement?
Yes, sure.
Is there-
Any case is going to be dismissed.
And then Ms. Gant's case is being dismissed, is that what you're saying?
Yes, sir.
Okay, but that's not included in this plea.
It's not, you can't take it into consideration.
Yes, I just want to make sure that we're clear on that. All right, so Mr. Duncan, understanding what you've been charged with and the range of punishment, how do you plead to possession of controlled substance in penalty group 2 less than 1 gram? And Mr. Duncan, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? All right, the court will accept Mr. Duncan's plea of guilt. Mr. Staub, any objection to states 1, the stipulation of evidence? All right, states 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, I'm just going to take a moment and review the evidence. All right, based on my review of the evidence, I do find there's sufficient evidence to support this plea. Court will follow the plea agreement in this case. the court convicts Mr. Zachary Perry Duncan of possession of controlled substance in penalty group 2 less than 1 gram, assesses his punishment pursuant to section 1244B of the Texas Penal Code at 5 days confinement in the Van Zandt County Jail. The court awards him 2 days credit towards that sentence for time served. Court also assesses a $4,000 fine, $180 restitution, $290 court cost, $35 reimbursement fees. The court also takes into consideration section 1245, DA 2020-522 and DA 2020-521. The court orders Mr. Duncan to submit himself to the Van Zandt County Jail on Friday, July 16th by 6 p.m. and orders him to be released on July 18th, 2021 by 6 a.m. Is Mr. Duncan making arrangements to pay any of his fines and court costs today, Mr. Staub?
Yes, we're gonna set the payment for
Okay, so he's not paying anything today. He's just going to set up a payment plan? All right, and Mr. Staub, have you explained to Mr. Duncan what happens if he doesn't pay his fees as agreed? And Mr. Duncan, are those your 2 little children out there on the bench? They're beautiful, by the way. They need you at home and at work, right? They don't need you in jail on this. They don't need you in jail for not paying your fines and fees. So I'm going to trust that you're going to do what a good father does, and you're going to make sure that that doesn't happen, right? All right, Mr. Duncan, it's very important that when you go to submit yourself to the jail that you have 2 things, a photo ID and a copy of the judgment. Otherwise, the jail's not going to let you in. A copy of the judgment that says I'm ordering you there, and a copy of a photo ID so they can put the 2 together and know that that's you. If you come without either one of those, they're not going to let you in. And that's just going to cause you more. That doesn't mean you don't have to do it. That means it's going to be problematic for you. Okay? All right, Mr. Duncan, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you come forward here to be fingerprinted by the deputy. And then after that, I want you to step over here and see Ms. Burns, and she can get you copies of that paperwork. Yes, sir, please. All right, cause number CR 2386, State versus Jamie Halise Gant. The court has considered the state's motion to dismiss and is granting the motion. Yeah, they're just gonna give him a copy of that, and they're gonna let him go. They're probably gonna send him out through this door right back outside.
Okay, perfect. And just so you're aware, stepping in for this.
Okay, let's go ahead and do that one. Mr. Kearns. All right, this is cause number CR 2199, State versus Matthew John Kearns, set for arraignment. Court understands that Mr. Heath Hyde has filed an appearance as attorney of record for Mr. Kearns and has asked the Honorable Derek Staub to stand in today for purposes of arraignment. Is that correct? All right, and Mr. Kearns, you accept that? Okay, go ahead, Mr. Staub.
Your Honor, we are here for arraignment today. So now we purchase this.
All right, court finds that Mr. Kearns has waived the formal requirements of arraignment and enters a plea of not guilty on his behalf into the record and sets this for pretrial on August 12th at 9 a.m.
So the first policy is okay for it's not affect the level of the-
Yes,
So we're attached to it.
yes. All right, did you do a notice of setting form for him? All right, do you have the,
Oh, I don't know.
yes, if you can fill that out for me, and then you just leave the white one with the court and the yellow one with Mr. Kearns. I appreciate it.
No problem. Thank you. Your Honor.
You're welcome. Thank you for helping today. All right, Mr. Do we have an update on Mr. Hogg on his UA? Oh. Maybe he's talking to him. Mr. Ashmore, are you ready?
Yes, Judge.
All right, Mr. Ashmore, let's see here. Jason Nichols, CR 2187. All right, Mr. Nichols set for pretrial. Are there any contested pretrial motions?
We don't have any yet, Judge. We do have discovery. We don't have a plea offer. There's pending family violence downstairs in the county court of law. Took a moment to go investigate that. That case is also very new. Looks like that one was charged on information about 2 weeks before this one was returned on the true bill on the grand jury indictment. So there's another attorney on that case. That case is set tomorrow. I'm actually downstairs tomorrow. I'm just gonna ask the court for a short reset, to figure out how to work all that together if possible, and then probably transfer one way or the other, up or down.
All right, court will find that there are no pretrial motions filed. Court will set Mr. Nichols then for docket call, August 10th or 12th. Do you prefer? And stay while Mr. Ashmore is looking, I would just ask the state if they're going to make an offer, they make it well in advance so that Mr. Nichols has time to consider that with Mr. Ashmore before the 10th, you said? All right, court will set Mr. Nichols in for docket call on August 10th at 9 a.m. All right, Mr. Nichols, once you sign the pass slip and you get the yellow copy, you're free to go. You're welcome. All right, CR 2333-334, State versus Grace and Fowler.
Judge, Ms. Fowler's daughter is not for interview today due to the short motion. Continue I filed last week, the short reset. She can't appear by Zoom, because I know we're kind of done with Zoom. My supplemental motion for her mental health exam, which was what we were going to consider her hearing on Thursday, is on file with affidavit and evidence to support it. And I'm just asking the court to either allow Ms. Fowler to appear by Zoom. She shouldn't be driving. She does not have a driver's license or a car. And her daughter just couldn't get her boss enough notice to be here with the holiday weekend. So if that's possible, Judge, I'd make that special request and ask to be excused, give her a Zoom number in the home, and get her on the Zoom.
I'll take just a moment. I have not reviewed the affidavit. Was it filed recently?
It was filed this morning.
This one,
Yes, sir.
because I looked for it last week.
Yeah, we were gonna file it last week and I had some personal issues. I appreciate the board allowing those continuances so I can do it.
Absolutely. All right, it hasn't been presented to me yet through the clerk's office, so I don't have that to consider.
I can step out. and
Let's,
They can
uh,
accept it.
well, I'll allow her to appear via Zoom today. She has been in contact with the court, so if you'll go tell her to log in, and we'll call her case via Zoom.
Okay.
As soon as Mr. Woodwhite gets back, I'll call your case, Mr. Stevens. Is it Jason Farney? Mr. Farney, if you'll go ahead and step up. It's a CR 21-164. All right, Mr. Farney, you are charged by indictment with the state jail felony offense of possession of marijuana greater than or equal to 4 ounces, less than 5 pounds. A state jail felony in the state of Texas has a range of punishment that, if convicted, the court or a jury could assess your punishment from a minimum of 6 months to a maximum of 2 years and a fine not to exceed $10,000. And any type of sentence in the state jail is a day-for-day sentence, and there is no parole. Okay, are you going to hire an attorney to represent you on this case? Okay, if I reset you for 30 days, do you believe that would give you enough time to hire an attorney and bring them back with you? I didn't hear that last part.
I also don't know if people.
Well, I'll tell you what, I'm going to give you till August 12th. So it's a little longer than 30 days. And so what I'm going to expect is when you come back is that you have hired an attorney. Okay. So I've told you about the seriousness of the charge. Okay. So I want that to impress upon you the seriousness of hiring an attorney to represent you on that. Might be the time that you reach out to friends and family also to help you. All right, Mr. Forney, the deputy is going to bring you this form. I'm going to have you sign right here, and then we're going to give you a copy of it. And then after that, I want you to come back and meet with the pretrial release department. Farney, Jason Farney, page 1 for me. All right, Mr. Hogg, if you'll step up to the podium there. This is CR 21-125. All right, and what's the update on the proposal? Did Mr. Hogg take his drug test? Did he? You would just tell me what they are?
Said he tested positive for.
I tested positive for marijuana.
Hang on, Mr. Hogg. Hang on. Let your lawyer talk.
Ms. Whitell come and tested positive for marijuana and for alcohol. Not believing if I'm not mistaken, he had come for someone who drank on the 4th of July. And spoke a little bit because he was stressed out. He said it was nothing. That's what I'm saying.
Okay, we'll get Mr. Waddell in here and we'll put him on the record.
So, I apologize for that, Your Honor.
Mr. Waddell, if you'll come forward, please. Mr. Waddell, I'm going to swear you in. Mr. Waddell, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Waddell, as the pretrial release supervision officer for Van Zandt County, I asked you to, actually, no, I didn't ask you to do a urinalysis. I believe that the parties asked, as a part of a proposal, that Mr. Hogg be drug tested today. Did you do that, and do you have the results?
Yes, the results were, he used marijuana a month ago, basically. He took for 6 and a half written down. And he also drank alcohol.
And was that as a result of an admission or a drug test?
The drug test showed that he admitted to using
Mr. Stevens, any question for Mr. Waddell?
it. No.
Mr. Woodwine?
No.
Thank you, Mr. Waddell. I appreciate you. Counsel, if you'll approach. All right, Mr. Hogg, what I'm going to do at this time is I'm going to place you in detention for violation of your conditions of pretrial release based on the drug test results and the admission. And I'm going to recall your case in just a minute, okay? So what I'm going to ask the deputy to do here is he's going to detain you. He's going to place you over here. And then Mr. Stevens has asked me to recall your case here in a few more minutes. So he's going to detain you right now. Go with him, have a seat. And then Mr. Stevens is going to let me know when you are ready to talk.
Yes, sir.
All right, Ms. Fowler, I'm going to need you to kind of get your phone nice and still.
Okay,
I didn't bring my Dramamine with me today, so
okay,
I want you to make me motion sick.
okay, I'm sorry.
It's okay. That's all right. All right, this is cause number CR 2333, CR 2334, State versus Grace and Fowler. The court has granted Ms. Fowler authorization to appear via Zoom today. Go ahead, Mr. Ashmore. And if you need to you may need to get closer to me so she can hear you, because those microphones are not on.
No problem, Judge. We're presenting today, one, I appreciate you allowing Ms. Fowler to appear by Zoom. We're presenting today our motion, our supplemental motion for competency mental health evaluation supported by affidavit and some extracted, one is a public record filed downstairs in the county court of law. And the other is a partially redacted excerpt from a emergency room discharge in support of our application for her mental health competency evaluation, Your Honor, and asking for a short reset to allow that to happen. So that way we can get that report, present it to the state, and see if we can resolve this case.
So is there still information you're trying to get to support the request for competency evaluation? You're saying you've got that and you filed it with your affidavit?
It should be filed with my affidavit and supported also by a business record affidavit from myself. So there's facts in the affidavit. Specifically, in 2015, her daughter petitioned the county court of law for a mental health hold on her mother, Grace, the defendant. And because her mother was a danger to herself and others, in 2017, she presented to an emergency room in Hunt County, Texas, where it was either diagnosed or confirmed diagnosis of acute bipolar disorder. She's had criminal charges throughout that process, which I believe are attributable, absolutely attributable to her mental health condition. And in addition to that, we've supported that with affidavit testimony from myself that Grace is having a real struggle understanding the charges against her. She really didn't understand the charges that she pled to last October, which she thought, and she was, I believe, downstairs. Gil Alton was her attorney. I interviewed him, although I didn't put that in the affidavits. I have interviewed him, and essentially Grace was unmedicated at that time. She'd been in the custody for some period of time, was not on any bipolar medicine. She was not on blood pressure medicine, which makes dealing with Grace particularly difficult. So we're asking the court to, through that affidavit and those medical records and court records, to find that a mental health evaluation is merited. And then depending on where that goes, present that to the district attorney's office, see if we can find some resolution on this matter.
Did I read in your motion that there was a recent hospitalization of Ms. Fowler? Or only hospitals? No, Ms. Fowler, it's okay. You're just listening. You're just listening.
Oh, sorry.
Or is that hospitalization 6 years old? Did I read that somewhere in your motion?
I only have attached to 2017. That's the only one I have. 2015 affidavit from her daughter in the court finding that she's a danger to herself and others.
Well, in the motion, it says that she's been committed by her family in the past 30 days. Is that not right?
That may be a typo. I don't believe that's accurate. I think where the confusion comes is she's, as I understand it, on July 16th, going to UT Southwestern for patient intake in their mental health center. But she hasn't been committed, and I'm sorry about that type. I'll file a conform.
All right, court's going to grant the motion for competency evaluation. I'm going to set this for hearing on August 24th for a status. Ms. Fowler, court is going to order Dr. Timothy Ingram to evaluate you for your ability to understand these proceedings and be able to assist your attorney in your defense. And so when Dr. Ingram contacts you, you're going to need to make arrangements to meet with him, and I'm going to order you to follow all of the evaluation procedures and protocols so that he can report back to me his expert opinion on whether or not he believes you're competent. You understand?
Yes, sir, I do. Thank you.
All right. And so I'm going to order you back before the court in person, August 24th at 9 a.m.
thank you for your, and I'm sorry I couldn't get there this morning, sir.
I understand. I appreciate you contacting the court. So make sure you stay in contact with your pretrial release officer, and we'll see you back on August 24th.
Okay, thank you, sir. Have a good day.
You too.
I don't know how to.
All right, we're back on the record, CR 21-125, State versus Matthew Tom Hogg. Mr. Hogg, you're still under oath.
Yes.
Go ahead, Mr. Stevens.
Please state your name.
Matthew Tom Hall, H-O-G-G.
Mr. Hogg, you and I have had discussions about what's going on this morning, correct?
Yes.
And you realize that the state is still offering to put you on the intensive supervision that would require weekly reporting. You understand that?
Yes.
And you also understand the judge's concerns because you told him that you couldn't report every week.
Yes.
Okay. However, you and I had conversation on it, correct?
Yes.
And you did make a 3-year probation out of Dallas, correct?
Yeah, it was actually transferred here to Van Zandt since I've been working and living here. And usually like on probation day, I just tell my boss and then you'll have the CEO driver just like park in the parking lot and wait. But I would like schedule it for like 9, because then we can go to Duke's, get fuel, eat, and then be at the probation place. So, around 9.
Mr. Hogg, what if your employer won't be willing to do that? What if he just says, no, I'm not going to do that? Then what's your
I have
alternative?
a neighbor that's been helping me out. My cousin, he lives in Curtis Creek. He has a vehicle, and I can buy a bicycle. Uber. There's some options. It's just I'm not used to asking people for a lot of help, like dealing with my own responsibilities. That's kind of one of my faults, but I do have a lot of people that will help me.
You realize the judge will want to see the control of probation. He doesn't want to put you on the spot with probation. He's got you.
Yes.
His concern.
Yes.
Are you telling this judge that you will make each and every probation appointment, no matter what time it is, whether it's at 9 in the morning or 4 in the afternoon?
No matter
You
what.
don't have the right or the ability to tell probation when you want to come in. You understand, right?
Yes.
Okay. And you do understand that if you fail to report, that there will be a warrant for your arrest. And in all practicality, if that happens, the offer that the state makes you today, as opposed to down the road, is going to be larger down the road. You understand that?
Yes, sir. I understand.
Okay. Are you telling this court that you will report as directed?
Yes, sir.
Even though you told the judge earlier you could report it once a month? You remember saying that, right?
Yeah. Well, I'm used to reporting once a month from when I was on probation. That's why I didn't know that that it would be like that much, but I mean, it's doable.
You can do it.
Yeah.
Are you asking this judge to put you on the probation?
Yes.
And are you telling him that we will make all of the reports?
Yes,
All of the
sir.
reporting or anything required of you?
Yes, sir.
Ask it.
You gonna drink alcohol while you're on probation?
No, sir.
Those handcuffs on your wrist tell me that you drank while you were on conditions of pretrial release. Why should I believe that you're gonna be better on probation than you were on my orders to comply with pretrial release?
I know you won't be as nice as you are right now.
Well, that's so
if there is
true.
a Next time, there won't be a next time.
All right, Mr. Hogg, I'm gonna go out on a limb here and I'm gonna take you at your word that you can do it. I take you at your word that you're not gonna be drinking and smoking weed and doing those things. And yeah, you're exactly right. It won't be as nice the next time you come back. Understand?
Yes, sir.
And you still want to go through with this?
Yes, sir.
All right, just leave him cuffed up. So, no, actually, go ahead and take those, if you'll go ahead and remove those cuffs. All right, Mr. Hogg. You've been charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC and a $10,000 fine. If I approve this plea agreement today, you'd be asking the court to convict you of this offense, sentence you to 10 years in TDC, suspend that sentence, place you on probation for 5 years, order you to pay a $2,500 fine, $290 court cost, order you to pay reimbursement fees of $1,165. Court would also be dismissing and evading arrest or detention and a driving while license invalid with previous conviction, and you'd be placed on intensive supervision. That's what you're asking this court to do today.
Yes, Your Honor.
And Mr. Stevens, you do believe Mr. Hogg to be competent today?
Yes, sir.
And you explained to him all of his legal and constitutional rights?
Yes, sir.
And you believe he understands everything that he's read and signed today?
Yes, sir.
And you've been given more time today to discuss various options with Mr. Hogg.
Yes, sir.
And you believe that he is intentionally, knowingly, and voluntarily selected this plea agreement that he's asking the court to approve.
Yes, sir.
All right, Mr. Hogg, how do you plead to evading arrest or detention with a vehicle? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, court will accept the defendant's plea of guilt. Mr. Stevens, any objection to states one?
No.
States one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from state, from the defense? Mr. Hogg, I'm having a hard time believing that you're gonna comply on probation after reading this.
Well, I have a lot of coworkers with cars. and my neighbors have cars.
No, it's not about that. It's about your unwillingness to follow rules.
I follow rules.
Well, this offense report tells me that a police officer tried to pull you over.
I only bashed my window in.
Well, let me talk and then I'll let you talk. All right. This tells me that a police officer tried to pull you over. Well, actually, that he approached you at a gas station, that you locked the doors to your vehicle, put your hoodie over your head and leaned over. He ordered you to get out. You refused. You locked yourself inside the vehicle. Told you to get out. He told you he was going to break the window. You still didn't listen. He says he told you 7 more times to get out of the vehicle. You refused to comply. He knew that you were driving without a license. He knew you had previous convictions. So he has to break out your window to get you to follow the rules, to follow the law. So he breaks out the window, tells you to get out of the car 2 more times. You still don't. He reaches inside, unlocks your door, opens the door. And while putting his stuff back up, you pull the driver door shut. They tell you to open it. You refuse. Then you put it in drive and you take off. And you lead officers on a pursuit with speeds from over 100 to 120 miles an hour. Lose control of your car, you go in the ditch. You decide that's still not enough, you get back on the road. And then you jump out and run on your foot. And that still wasn't enough. They had to tase you.
Yeah, it's on my front.
All that true? Is all that true?
No, not all of that is true at all.
What part's not true?
Him asking me to get out, multiple times.
How many times did he ask you?
He didn't ask me to get out, he told me to roll the window down, but my window don't work. And then he got on the radio, and then I guess the officer in charge gave him permission, put through a matchstick and bashed the window in, and then he reached in there. He wasn't asking me to get out. He unlocks it, and he's trying to pull me out of there, and I was frightened for my life. I was on a dark road, and there was 2 police right there, and like that officer was like arrested me multiple times and towed multiple vehicles that I owned, and I was frightened. Like even on the body cam, like you can see me, I'm like, no, like I started screaming like a little girl, and I was frightened, and I just drove straight to my house. Like I didn't really run that far, from my driveway to my front door.
Did you drive over 100 miles an hour?
My Buick only says 100, but I was frightened. Like,
So is that a yes? Is that a yes or a no?
Like in the moment, I really wasn't paying attention to how fast I was driving. I just know that like I was frightened. They like bashed my window in, glass flew up my face, and they were trying to pull me out of the car. And I really, like, these classes I've been in, it's like fight or flight. It's like natural instincts, and I flew.
You seem like a pretty smart guy, Mr. Hogg. What's a red flag? You know what a red flag is?
Red flag?
Yeah. If I said, hey, this is a red flag, what does that mean to you?
Like a Russian flag?
No, I didn't say
It's a
Russian.
little yellow.
No, I said
I don't know what you mean by.
just a red flag. You know what a white flag is? You put out the white flag.
Surrender, yeah.
You know what a red flag is? If I
No,
say I'm reading this, I'm seeing red flags.
warning signs.
Warning. What do you think I'm worried about?
Oh, I'm not getting in another vehicle until I have a license. I mean, I'm not driving another vehicle, not even a side by side, four-wheeler, nothing. Anything with a motor, I ain't driving.
I'm worried about you doing what I've ordered you to do. You didn't do what the police officer who's got a gun on his hip and a baton and he has to break out your window. You don't even do what he's doing. I don't even carry a gun. I don't even touch this thing. And you're not gonna do what he's gonna do?
Well.
So how should I be, why should I feel confident that you're gonna do what I tell you to do in these conditions?
The Basin County Sheriff's Department has taught me to cooperate with the law. Your Honor. For sure. Yes, officer, no officer. They have taught me to cooperate. For sure.
Mr. Woodwike, this is your recommendation?
Judge, Mr. Hogg, through Mr. Stevens, after his arrest, immediately approached me regarding, I believe to be intoxication issues. And I question, I think there are some mental health issues. It appears to be one or the other. My hope is they give him proper support structure. He gets assistance with that. That's the basis of this. As I believe said before, I have offered him 3 years in the penitentiary is the alternative. I've asked Mr. Stevens to make Mr. Hogg fully aware that he goes back on revocation, that it is much, much closer to the 10 than the 2 that he's facing. I have hopes that Mr. Hogg will be successful. So I have control of that. It is my recommendation. At this point, with his assurances to the court that he will be successful. I have concerns as well that falls in Mr. Hogg's court. And my court, if it comes back to it, will be a substantially harsher penalty than he's facing right now. If he needs to take that this time.
If I may say something, I too agree with the prosecutor. I think that some tight reins on Mr. Hogg will do him good in his personal life. He needs it. I do believe he's at a point in his life that he's going to do what he's supposed to do. You don't like getting locked up, Mr. Hogg?
No, sir.
Okay. Are you, if you are involved in the case in the future, you're going to cooperate?
Yes.
No matter what the circumstance, so even if you don't like the way they're approaching you, or even if you feel like you're being wrongfully detained for whatever reason, are you still going to cooperate?
Yes. I mean, I've already had the police at my house because, I'm like evicting somebody that I've been sitting at my house the whole time I was incarcerated for 90 days. And, yeah, I've cooperated with the police again and, I mean, I'm gonna do what I have to do to get to this probation, for sure.
All right, Mr. Hogg, I'll be honest with you, my gut tells me not to do it. My gut's been telling me all day, these red flags keep popping up. My gut says, don't do this. Don't do this. But I'm gonna give you what you asked for. Because Mr. Woodwike's making the recommendation, Mr. Stevens is making the recommendation. I'm gonna follow the plea agreement in this case.
Thank you, Your Honor.
But I promise you that if you come back on any type of violation on your probation, anything, if I find out one moment that you're giving the probation officer problems, that you're not listening, that you're not complying, There will be no more plea agreements. I don't care if the state comes in here and says, we'll give you 3. I will not accept it. I will not accept it. I will give you a hearing and then I will assess your punishment. And I can assess all the way up to 10 years. Do you hear me? I can consider all the way up to 10 years in prison. I want us to be very clear. All right, Mr. Hogg. Court follows the plea agreement, assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence pursuant to the recommendation of the state, place you on community supervision for 5 years. Court assesses a $2,500 fine. Court 1245's DA 2021-424, DWLI, DA 2021-425, evading arrest or detention. 2020-481, driving while license invalid with previous conviction. Court places you on intensive supervision as a condition of community supervision. Court orders you to pay court costs of $290, orders you to pay reimbursement fees of $1,165. Mr. Hogg, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions. I'm sorry, to the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. After you are fingerprinted with the deputy here, I'm gonna have you step over here to your left to the probation department.
Yes, sir.
Yes, sir. Yes, sir.
Issue not. I have a theoretical issue of the court's interpretation of certain sections of the Code of Criminal Procedure.
What section?
Specifically, Article 17,
All right. Court has called Devontae Bird, Cindy Smith, and Tyler McInnes's name. None of those individuals were present at 9 a.m., nor are they present at this time. Court is going to find that each have received notice of today's hearing, have failed to appear. Court orders a judgment nisi and alias capias in each cause. And that completes the court's morning docket. We will resume online and in person at 1:30 p.m. Thank you, Mr.